So the question was, are there legal avenues to pursue? And the question seems very simple on its face, but it's really not. Because if you're asking under conventional law, are there legal avenues you can pursue? The answer is no. If you're a community that wants to ban fracking, but you're in a state where the state doesn't allow your community to ban fracking, you have no legal avenues to pursue. So you got to switch to the other side about what you want the law to be, not what the law is. Because as the law is right now, there's no legal avenues. The Longmont case, the Colorado Supreme Court, that's all been answered. You're in a state that's in lockdown. You're a lockdown state, your municipalities don't have the power to ban fracking. So under the law as is, the answer is no, you have no legal avenues.
Have you been going home rule as a county?
Well, home rule is not really home rule. A home rule, which sounds funny, but home rule is a legal term, but it's also just a general use term. It doesn't mean that you're free from the state's dictates. The state can still control you as a home rule community. It just takes a little more time to do so than as a general statutory body. So under the law as is, the answer is no. But as we've been talking about today, we can't let the law sit as is because that's a suicide pact. It's a suicide pact to let the law stand as is. You got to change the law. How do you change the law? You change the law through disobedience. People refusing to follow the law as is, to build new law. And this system, the U.S. system of law, has made new law before. Not on its own, but with the help of the suffragists and the labor movement and the abolitionists and indigenous rights movement. I mean, it has to be forced. That change has to be forced. And so the law that needs to be is one in which municipalities have the power to ban those things that are harmful to them. And that means communities having the power to override those doctrines I talked about earlier, preemption, Dillon's rule, corporate rights, making a community powerful enough to actually have a portal through which people in the community can drive law to actually stop that which is harmful to them. That's the law that needs to be. How do you get the law from as is to law that needs to be? The only way to do that is to disobey the law as is. And that takes a variety of forms, but it has to be broken. You have to break that thing. You have to understand it before you break it, because you have to understand how you're breaking it. But once you break it, it's to move in that new direction. We argue to judges that law should be a different way, that there should be a constitutional right for communities to do X, Y, and Z. That has not gained purchase in the courts. And a lot of communities across the United States are now driving constitutional amendments to their state constitutions to change the status of communities. Just like in Colorado, EBCU and the Colorado Community Rights Network were the leading players in putting the first constitutional amendment into language that passed the initiative board and went through the state process with the help of Libby. Where's Libby? Oh, Libby's in front. So that's the kind of stuff that has to be done to change the law. But the history of this country is that law doesn't change unless it's forced.